out, we'll be sending the recording. I'm just going to click that on mine as well now. So yeah, we'll keep an eye on the chat throughout. Liam obviously very kindly offered to answer some of the questions that were put to us beforehand, and we'll run through those as well as a bit of an overview about the building safety bill, what that means in practice, how it works, and some of the timelines. And yeah, so I guess Liam, do you want to kick off?
Yes, thank you for that very kind introduction, Sophie. Very happy to join everyone here this evening. I only wish it were under better circumstances, but I think many of you know me. I am an affected leaseholder, and by trade I am a litigation solicitor, so by no means an expert in housing or landlord and tenant law, but I'm happy to share with everyone my impressions of the bill.
Liam, I'm really sorry, but your sound is really bad. You sound like you are drowning. So, I mean, we probably all are, but like literally, not just metaphorically.
Let me.
Oh, try again.
Is that better?
Perfect.
Yeah, that's fine.
Yeah, perfect.
Okay. Yes, so as I was saying, I am Liam Spender. I'm an affected leaseholder. By trade, I am a litigation solicitor, but by no means an expert in housing or landlord and tenant law. But I'm happy to share with you my impressions of the bill based on what we've learned over the past few months as it went through Parliament. And in a minute, I'll put up some slides and we'll talk through the main issues from a leaseholder's point of view. And it's the key thing to remember is this anything I say tonight won't be a substitute for legal advice. So if you find yourself in a lot of the questions that came through were very specific, and I wouldn't be able to answer them without knowing all the ins and outs of the facts of that particular building. So we'll just deal in generalities this evening, and it won't be a substitute for legal advice. So on to the presentation, which I'll put up now.
I'll just add as well, we're probably not going to go to accounts with raised hands or anything for people to speak. So please do, if you have a question throughout, drop it in the chat or in the Q&A section, and I'll be monitoring that and have a chance to put some of them potentially to Liam at the end, or we will potentially look to answer some of the main topics that were raised outside of the webinar after the call. It's just a heads up.
Okay, thank you, Sophie. These slides will also go up on the EOCS website after the presentation, and if I get time, I'll also try and write a frequently asked questions article for the Leasehold Knowledge Partnership website as well, but that will have to wait until the final text of the bill is published. So what I'm going to do this evening is go through the bill in 4 parts. You'll be relieved to know most of the time this evening is allocated to answering questions rather than me giving my impressions about the bill. But I'm just going to give a very brief overview of what the bill is, what it does specifically in relation to service charges, the pieces of the jigsaw we're currently missing. Unfortunately, there are quite a few, and then I'll go on to answer the questions that were put in advance. And as I say, these slides will go up on the EOCS website after this talk sometime this week, I hope. So the Building Safety Act, as it now is, was passed by Parliament right at the end of last month. It got Royal Assent, the last stage, on the 27th of April. It is an enormous piece of legislation. There are more than 260 pages of it. 170 clauses and 11 schedules, so it's no easy read at all, and it will take a long time for it to bed down. I expect there'll probably be quite a lot of time spent interpreting what various parts of it mean. Currently, at the moment, it's not yet in force, so it doesn't have any legal effect. It will come. In fact, it's not even been published in final form, which I suspect is to do with partly how late in the last session of Parliament it was passed, and partly because it's so complicated. There are an awful lot of cross references between different parts of the law and between the law and other laws that all have to be checked before it can be published in final form. So we're still awaiting that. The bits that leaseholders are most interested in that deal with service charges come into force, into legal effect from the 27th of June this year. And then the rest of it will come into force over the next 12 to 18 months, perhaps longer. So it will take a long time for it to come fully into legal effect. And in addition to the complexity in the law itself, it's further complicated by the fact that a lot of the details are not stated on the face of the Act. They rely on statutory instruments, which we haven't seen, and there'll be dozens upon dozens of those statutory instruments that you'll have to go away and read to understand exactly what the bill does. So it will be no easy law to navigate, and it sits in a very complicated way alongside non-legislative measures like the Building Safety Fund, the recently announced Developer Building Safety Pledge, and the promised Orphan Building Scheme, which I'll come on to talk about. So the Act does much more than the small part of it we'll be focusing on this evening, which is mainly about service charges. It touches every aspect of a building, from design to planning to building control to occupation, and probably the most significant change is in, at least from a leaseholder point of view, is in the occupation phase. So when that part of the Act, which is Part 4, comes into force, living in buildings taller than 18 meters or which have more than 7 stories is going to get a lot more expensive. I think at least for the first couple of years, and perhaps well into the future. And as you can see on the slide, the bill also deals with new rules for approved inspectors, construction products, new home builders, and architects. So a far-reaching change. The bill also sits alongside the Fire Safety Act. So that was passed in 2021, but that still isn't in force. So we've been waiting for the past more than a year now for that to be brought into force. But when it does come into force, all buildings of any height containing 2 or more self-contained sets of domestic premises, so 2 flats basically, will have to have their external walls assessed annually in accordance with a standard called PAS 9980. And we don't know how that will work in practice, what effect that will have, or even if there are enough inspectors. There probably aren't to go around doing all those inspections, and we're not entirely sure when the Fire Safety Act will come into force either. In addition to the Building Safety Act, the Building Safety Fund, which used to pay for cladding remediation works on buildings above 18 meters, will be reopened to new applications. Again, we're not sure when, but buildings more than 11 meters tall, 11 meters and above, will be able to apply for help with cladding if they can't get help through other routes. The government's recently announced that it's reached a deal with some of the largest developers that they will take responsibility for remediating buildings they have built over the last 30 years. We need to see the detail of the contract between the developers and the government to understand exactly what that pledge means in practice. But the headline is supposedly that if you live in a building built by a developer and the developer signed the pledge, that you shouldn't be paying anything for cladding or non-cladding costs. And we're also expecting a scheme, although that's still in the works, to be announced where orphaned buildings, that's the government's label for them, that's where no developer is still in business, or the developer can't afford to pay for remedial works, hasn't signed the pledge. There's supposed to be some sort of scheme where those buildings will be taken care of, but that's one of the big pieces of the puzzle that we're missing at the moment. And in addition to those changes, the Act also introduces new legal rights, which are, at least on the face of it, better than what went before, because as we all know, the issue with the legal rights that prevailed before the Building Safety Act was they were limited to 6 years from the date of completion, or they left out the ability to recover economic loss. So you couldn't recover for having to pay out for waking washes and insurance, because the law didn't allow you to recover that kind of loss, and you couldn't sue building inspectors for the consequences of them failing to do their jobs properly. So there's been some limited reform in those areas. In particular, the Building Act 1984 section 38 is coming into force. So that will allow you to sue building inspectors for negligence, but not for economic loss. So if your loss is purely to do with money, you still won't be able to get that back, even if the building inspector was negligent. And the oh, sorry, I've skipped forward there. So that's only a small advance in the right direction. And the other changes to the Defective Premises Act, which is the main way people had rights of recovery, the Building Safety Act changes that to extend to renovations and conversions, as well as brand new buildings. So the duty to build a building that is habitable is extended to renovations and conversions. There's also a retrospective limitation period. So buildings built within the last 30 years can bring claims under the Defective Premises Act if the developer's still around. And if your claim is one of the ones that's brought back to life under the Defective Premises Act, then you've got 1 year from the 27th of June to put your claim together and make it. But that's only likely to be of use if you've got a solvent developer to pursue. So the Act also introduces new rights to bring claims against construction product manufacturers for breach of duty and for breach of regulations, which we'll talk about a bit later on. And for new buildings, there's a new 15-year compulsory insurance scheme that will be brought into force at some point in the future. So improvements on where we were before the Act was passed. So the bit we're probably all interested in is, what does the Building Safety Act do about service charges? And in a nutshell, it changes the law in relation to service charges. So for relevant defects from the 27th of June 2022, service charges can't be passed on to leaseholders in qualifying buildings in relation to relevant defects. And a relevant defect is, you can see it on the slide there, is something done or not done, or used or not used, that creates a risk of spread of fire or collapse of the building, such that it's a danger to the people living there. So quite a broad definition. Includes defects that are caused by professional negligence. So that means if there's something wrong with the design of the building that causes a risk of the spread of fire or the collapse of the building, then that in itself is caught by the definition of defects. It applies to all buildings built since the 27th of June 1992, but they have to be taller than 11 meters or have 5 stories and above to be caught. So if you live in a building with 4 stories, or if you live in a building that's not 11 meters tall, these new service charge protections don't apply to you. People who live outside of England are also not going to be helped by the Building Safety Act. So people in Scotland, Wales, Northern Ireland have to wait for those devolved nations to make their own laws. Another key gap is if you live in an enfranchised building, so a building that's owned by its residents or some subset of them, you're also not covered by the new service charge protections. And then, as you can see right at the bottom of the slide, which has been an issue a lot of people have asked questions about, if you live in a building that's managed by a resident management company or a right to manage company, then you're also effectively excluded from the protections because of the way landlord is drafted in the law.
There's a question there just in the chat as to whether there's still a distinction between right to manage and enfranchised buildings, or if they've been merged for the bill.
Yes, so the difference between the two is enfranchised buildings are excluded on the face of the bill. They don't get any help because they're excluded from ever being a relevant building. Right to manage companies and RMCs are they're not excluded on the face of the Act, but the way the definition of landlord works means there's no effective protection for the leaseholders living in those buildings. And I've got a slide on that later on, but that's the general distinction. So specifically in relation to service charges, the Act, what it does not do is give anyone the right not to pay or to withhold their service charges. That's not what it does at all. Instead, what it does is it bans qualifying leaseholders and qualifying buildings from being sent demands to pay service charges. So it works at one level removed, if you want to look at it that way. So and as you can see there on the list, the ban is work. So leaseholders shouldn't be asked to pay anything before developers and landlords have been approached to pay. No leaseholder in a building more than 11 meters tall or with at least 5 stories can be made to pay anything towards cladding, and cladding systems defined in roughly the same way as the Building Safety Fund. For non-cladding costs, leaseholders can't be forced to pay more than a certain amount, which is related to the value of their property. And non-cladding remediation is defined in the Act as a relevant measure, and you've got the definition on the slide there. So quite a broad definition. It means anything done other than to an external wall to eliminate, reduce the severity of any risk arising from a relevant defect, which, as we were talking about on the other slide, means anything that contributes to the risk of spread of fire or to the collapse of the building. So not a relevant measure under the Act includes waking watches, fire alarms, as well as things like internal fire stopping, compartmentation works, things like that. And in addition to those bars to recovering service charges, qualifying leaseholders can't be billed for any professional services, so legal fees, surveyors fees, experts fees. They can't be passed on to leaseholders in qualifying buildings either. That's from the 27th of June, not today. And as I mentioned at the start of the presentation, but we're still missing a lot of detail. So if you live in an enfranchised building, and we hope also if you live in an RMC or an RTM, the government promised a consultation would be carried out on how to deliver protection from service charges for those buildings, but we don't know when that will happen. As I mentioned, we're also promised a scheme to look after orphan buildings, but which is supposed to be paid for by a special tax on developers. But again, we're lacking detail. And as I also mentioned, we're in 2 months' time less than 2 months' time now, when the service charge protections come into force, we're also missing a lot of the detail. And you can see it on the slide there about how the protections work in practice, because we don't know key pieces of information like how is the flat to be valued for the purpose of any capped contribution and things like that. So on to the questions part of the presentation. Obviously, the most popular question in the ones that were sent in advance was, what is this waterfall? How does it work? And what happens if there's not enough money to do the works at the end of the waterfall? So the easiest way of explaining it is, before the Building Safety Act came into law, the position was that leaseholders could be billed any amount of money for any defect on the building unless they could get the developer to fix it, the landlord agreed to fix it, or they could get help from the Building Safety Fund. The Building Safety Act has replaced that system with what's called the waterfall, or the cascade, whatever you want to call it. And what that does is, instead of leaseholders being the first port of call for all of these costs, they become the last port of call, and landlords and developers move up ahead of leaseholders to the top positions. So they're expected to pay first before leaseholders have to pay anything. And obviously, when I'm talking about leaseholders in this context, it's qualifying leaseholders. So unfortunately, only those in buildings taller than 11 meters or with more than 5 stories. So what the waterfall says for those leaseholders is, if someone wants to levy a service charge, they can't ask leaseholders to pay anything for cladding works. If the landlord is associated with the developer, they can't ask leaseholders to pay anything. If the landlord isn't associated with the developer but is of a certain level of wealth, the landlord itself has to pay for both cladding and non-cladding works. And only if those 2 layers of the waterfall don't produce any money can leaseholders be asked for contributions to non-cladding costs only. And those contributions are capped depending on the value of their property. So that is roughly what the waterfall does. Obviously, the big unanswered question is if you live in a building where the waterfall provisions are triggered and there still isn't enough money to do the works, what happens then? And the answer to that isn't at all clear, unfortunately. So who is a qualifying leaseholder? Am I a qualifying leaseholder? What happens if I've got joint ownership or partial ownership of property? That was another popular question in the ones that were put in advance. So to be a qualifying leaseholder, we look at the position on the 14th of February this year, not today, not on the 27th of June, but on the 14th of February. And if on that date you were someone who only had 1 property in the United Kingdom, then you are a qualifying leaseholder. Or if you're someone who did not own more than 2 other properties in addition to your main home, then you will be a qualifying leaseholder. And the way the Act is worded, it looks at whether you have a freehold interest in more than 3 properties. So if you own a house by yourself or jointly with someone else, that will count as a freehold house, that will count as one freehold property, regardless of your interest in it. And in terms of if you own more than one flat, the test is whether you're named as the second, third, fourth, or sole tenant on the lease. And again, if there are, say, 4 people on the lease and you're one of them, that will count as one lease. So joint ownership, the Act doesn't have any regard to your precise share. It's just a yes/no test. Do you have an interest or not? So if you've got your main home and 2 flats, you will be covered. If you've got your main home and 3 flats, you will not be covered. If you are covered, there's 1 cap per property, and we'll talk about the value of the caps in a minute, not 1 cap for all properties. And if you're above the property limit, then you don't get any help. You're just treated as the same as you were before the Act was passed. So how do these caps work? Do shared owners have to pay the full amount? What if I've already paid more than the value of my cap? When do the caps apply? They were all common questions in the 180 odd we were sent through. So the caps apply to service charge demands that are made on or after the 27th of June this year, and which are made in respect of relevant measures. So you remember a few slides ago, I was talking about how a relevant defect is defined, how a relevant measure is defined. So a relevant measure is anything done to a cladding system or anything done to stop the spread of fire or lessen the risk of the spread of fire, or to stop a building collapse, or to lessen the risk of a building collapse. So that's what the protection applies to, demands in respect of those things. So it's important to understand how your individual lease works in terms of when demands can be made and what you can be made to pay for, because the quality of this system, this waterfall system, and the service charge protections under the Act depend entirely on how good the landlords are at following the new law. So we'll have to keep an eye on how that works out in practice. So as I mentioned, the caps work by the value of your flat. That is not the price you paid for your flat or the price you could get for your flat today. It's the way it's going to be valued is to be determined by a method to be specified in a statutory instrument. We're told that means the government will work out what the value of your flat is by using the house price index. That's not final. That's what they said in Parliament as the bill was going through. So we still don't know how it will work in practice, but we do know it won't be the sale price or the market price, because people tried to amend the Act as it was going through Parliament, and those attempts to amend it to either of those 2 values weren't successful. So the way that the caps work is if you live outside of London and you have a property worth less than 175,000, you don't pay anything to non-cladding costs from the 27th of June. If your property is worth 175,000 but less than 1 million and it's outside London, you might have to pay up to £10,000 for non-cladding costs. Different levels apply in London. If it's worth less than £325,000 in London, you pay nothing. If it's worth between 325,000 and 1 million, you might have to pay up to 15,000. Properties anywhere that are worth above 1 million pay up to 50,000. Properties worth 2 million anywhere pay up to 100,000. Those figures are for non-cladding costs. According to the government's own statistics, these thresholds take 60% of people affected out of paying anything at all, so that it's only 40% of people who should pay something. And according to the government, virtually everybody in that 40% will pay less than the value of the caps. I haven't seen the evidence that underpins those numbers. That's just what they say. Whether it's true or not, time will tell. And the reason I've put the 1 million figure on there is not because I favour millionaires or even because, unfortunately, I don't live in a £1 million flat. But the way the valuation method works is if you bought a flat for £600,000 or £700,000 many years ago, which may actually be a very modest property, the valuation method the government uses could put you in that £1 million bracket, even if it's not a price you could fetch on the open market for that flat. So I think this is something that needs looking at very, very carefully. But the good news is if you're a shared owner, at long last, you're not dumped with 100% of the bill if you don't own 100% of the property. So you, as a shared owner, if you do have to pay a capped amount, you only pay your share of the equity in the property. So the example there is outside London, if you're a 50% owner, you'd only pay £5,000, not £10,000. Potentially, I don't know if people are staircasing at the moment, but the test is at the 14th of February. So if you were a 50% owner on the 14th of February, and since then you've become a 100% owner, the good news is you still only pay 50% of the cap. That's what the Act says, because it looks at the situation at the 14th of February. Even if you do have to pay a cap, the cap can't be demanded as a lump sum. It can only be demanded at the rate of 10% a year. So it's basically automatically scheduled over 10 years. But I don't know how that will work, because normally the way major works, such as remedial works, are carried out is the landlord collects all the money up front and then pays it out, and the works don't start until all the money is available. And I don't know many contractors who would offer a 10-year repayment plan. So I don't know how this 10% limit will work in practice, but that's what the law says. Theoretically, you can set off certain amounts you've already paid against the value of the cap. So if you've already paid for waking watch and survey fees, legal fees, a new fire alarm, things like that, if you've already paid for that, your share of those costs can be set off against the value of your cap. So it's possible that some people actually have a cap of 0. They may even be owed money. They may have a negative cap as a result of money they've already paid. But the issue with that is it's unlikely to be of any use if you live in an enfranchised building, because the only source of a refund is you yourself as someone with a share in the ownership of the building. So it's only if you've got a third-party landlord that a refund right is of any use. And I don't know what happens if there's already a waking watch in place and the leaseholders have reached the value of their cap, but it's not possible to remove the waking watch, because presumably if the waking watch goes away, you could potentially be looking at an order to decant the building. So I'm not really sure how much use the cap is in a situation like that. But that is what the law says. This set-off right applies from the later of the 27th of June 2017 or the date you became the tenant. So if you moved in after that date, you can only set off service charges you personally have paid. The fact that your predecessor entitled, whoever sold it to you, paid charges, you don't get to count what they paid to against your cap. You can only count what you personally have paid. And landlords will have to give information about what you've already paid as a condition of being able to collect further service charges towards these relevant measures. And as foreshadowed in the explanation I just gave you, theoretically, there's a right if you already paid more than the cap. The government is supposed to be issuing regulations saying how you get a refund from the landlord. But as I say, that's only of use if the landlord is independent of the leaseholders, and we don't know what that right will look like until we see those regulations. So the next one is, which was another common question, is what happens if the landlord is, well, before I answer this, I'll give a recap. So the idea behind the waterfall is developers and landlords pay first. Only if they do not pay can non-cladding costs be passed on to ordinary leaseholders. So the government's hope is most leaseholders won't have to pay anything because someone else, the developer or the landlord, will pick up the bill. And it's only if you're in one of those unlucky buildings where the developer or landlord does not pick up the bill that the caps could potentially be triggered. So it's important to understand that the caps aren't the default position. Your landlord cannot send you a bill for £10,000 or £15,000 and say the law requires you to pay this, because it doesn't. So that's just by way of recap. And that was actually a much quicker way of explaining it, so I probably should have said that at the start. But anyway, so what happens if my landlord is already holding money in reserve, which is in excess of my cap contribution, or what if the landlord has already started, is partway through, or has finished a Section 20 consultation process, and what if works are already underway? They were common questions in the ones that were sent in advance. So the way the Act works is, if the money in reserve was demanded before the 27th of June, then it can stay in the reserve. That there's no change to that position. And if you already have a service charge demand that requires you to pay money into reserve, even if it's in respect of cladding or non-cladding works, because the law isn't in force yet, you will still have to pay that demand, even though the money's only going into reserve. The issue is, once the new service charge protections come into force, so after the 27th of June, if the landlord tries to spend money that's in reserve, then it's caught by the new service charge protections, because the new service charge protections both stop the landlord asking for service charge money and stop the landlord from using money that's in a reserve. So after the 27th of June, the landlord won't be able to spend money. And as I read the Act, is also going to be obliged to refund money that people have paid in excess of the cap. I would be amazed if any landlord voluntarily handed back money. I think it will depend on what the regulations say. I think inevitably there'll be some sort of litigation over it. Landlords won't want to let go of money they've already collected in, but the way I read the Act, that is what they're required to do. Whether they do it or not is a different question. So if the landlord makes a service charge demand on or after the 27th of June, then it's subject to the new rules, even if it's going into reserve. So the problem with the way the service charge protections work is the landlord can't collect money and put it into reserves, which underlines the issue about being able to pay contractors up front. If the money's not in reserve, the landlord can't do that. So I'm not sure what practical effect that will have in terms of getting works done for buildings where the money's already been set aside. That seems as if it'll be a major bone of contention. And the same as if works are already underway and the money's coming out of reserves and people have already paid up to the value of their caps. I can see an issue there, because legally the landlord can't hand over that money from the reserve to the contractor. And then on the the issue about Section 20 consultations, so anytime a landlord wants to do works that require spending more than £250 per leaseholder, unless it's under a framework agreement, they have to go off and do a consultation process where they show you estimates and give you the opportunity to comment on them. And only once they've done that can they pass on their full costs. But that's all Section 20 allows them to do. What a Section 20 process does not allow a landlord to do is to send you a bill asking that you pay service charges if that's not what the lease says. So, for example, my lease says the budget is fixed once a year and it's paid in 2 6-monthly installments. There's no opportunity under my lease for the landlord to send me a bill in April for some extra amount of money that wasn't in the budget that was set the previous December. If it wasn't in that budget, it can't be collected until the following year. A lot of leases will work like that. Some leases do allow in-year adjustment. So this is why it's important to know what your own lease says. If the landlord can send you an interim bill during the year, then those bills could follow after a Section 20 has been completed. It depends what the lease says. But in cases where the lease doesn't allow the landlord to send a bill, they have to go off to the tribunal and make something called a Section 27A application for an order that they can issue a bill outside the terms of the lease. If that application requires service charges to be paid on or after the 27th of June, then it'll be subject to the new law. The tribunal won't have the power to order people to pay more than they're obliged to pay under the Act, even if the Section 20 works require more than that contribution from leaseholders. But again, expect an enormous row over that. It's at least one site, if not more, because that's just the nature of the beast. So as we've talked about, in franchise buildings, which are buildings where some or all of the leaseholders have bought the freehold or bought the head lease, they have been deliberately carved out of the service charge protections. And can I explain in more detail why resident management companies, RMCs, and right to manage companies, RTMs, aren't carved out but still don't get the protection? So in a nutshell, enfranchised buildings have been carved out because the owners are the residents and the residents are the owners. So if you try to put in a restriction on service charges, the company that owns the head lease or the freehold just turns around to its shareholders and says, shareholders, you need to give me the money. So there would be no point putting protection in that case. So the government decided to leave those enfranchised buildings out. The test is at building level, not at individual level. So if you're in an enfranchised building, but you're not one of the co-owners, it doesn't matter. You're still in the same position. You don't get better protection than your neighbours. And the government's promised a consultation on what to do about these buildings, but we don't know what that will entail, when it will happen. And in the meantime, people who live in enfranchised buildings can be billed an unlimited amount of money, which you'd hope wouldn't happen, because the residents are the owners and the owners are the residents, so they have control over what happens. But if you live in a building where you can't get insurance or people can't get mortgages, what option do you have but to go ahead with the work? So I think there could be buildings where there are a lot of unpalatable choices to be made and to be discussed. And then RMCs and RTMs, why are they missed out from the protections, even though they're theoretically included within them? Well, the answer's the same. It's because the owners are the residents and the residents are the owners. And the way the bill works is the way the act works is it says a landlord is anyone who can enforce a service charge, and that is what resident management companies and right to manage companies do. They collect service charges, so they're deemed to be landlords. So that means in those buildings where if the developer doesn't pay and you come down to the landlord level of the waterfall, the landlord is effectively the leaseholders in a different guise. So if the landlord has to pay the RMC or the RTM, it turns round to its shareholders and says, you need to give me money because otherwise the company can't meet its obligations. And normally where you've got an RMC or an RTM and it can't meet its obligations, the lease will say that management goes back to the freeholder, which, well, not the freeholder or the head lessor, the actual beneficial owner of the building, which often defeats the point of having residents in charge in the first place. And because the Act looks at the situation at the 14th of February, not at the dates, the service charge demands have to be made. Collapsing the RMC or the RTM because people won't pay in their capacity as shareholders doesn't mean that the actual beneficial owner of the site is landed with responsibility, because they weren't collecting the service charge on the 14th of February. So it becomes an unpalatable catch-22 situation. So the best we can hope for is that the consultation we've been promised will deal with the RMC and RTM issue as well as the enfranchised buildings issue. So another common question we had was which developers have to pay up under the waterfall, what sorts of works do they have to pay for, and how are landlords deemed to be connected to developers. So and this is one of the most complicated areas of the service charge provisions in the Act, or all this connection between developers and landlords. But explaining it in a very simple way, there are 4 ways a developer can be made to pay. Either it does a voluntary deal, or it's signed the developer pledge, or it's because it's connected to the landlord, or it's because there's a different legal means that either under this Act or under the law, or because you bought off plan and you're still in time to make a contractual claim. Those are the 4 main ways that a developer can be made to pay. So a developer is deemed to be associated with a landlord if there were shared directors or shareholdings or means of control, or there was a joint venture, or if the landlord is in the same group as a developer, and developer is defined as someone who commissioned the construction of the building or built the building with a view to granting leasehold interests in it. So, for example, many of the large housing associations, because they have blocks built on spec for them, they don't just go off and buy blocks that happen to be for sale. They actually commission blocks being built. They will be classed as developers under the Act, so they will have to pay. They won't be allowed to pass any costs on for cladding or non-cladding costs. And if you've got a housing association where one company within the housing association group is the landlord, but the housing association had a block built on spec for that landlord to run, then that would meet the association test. I think in terms of private developers, Ballymore and Galliard are two examples of private developers where the developer is the landlord and the landlord is the developer. It's all done in-house, but Ballymore says it will fix all its own buildings, and Galliard has belatedly signed the developer pledge so that they've agreed to pay anyway. So what does the developer have to do? If it's forced to pay under the Act, what standard does the work have to reach? There is no fixed standard. It's largely going to be if the landlord's choosing or the developer's choosing, because the developer's the one that's paying for it with no right to recover the money from leaseholders. But there are some constraints in that. They're going to have to get a professional to sign off on a PAS 9980 survey, so they'll have to do works that meet that standard as a minimum. And if the landlord is responsible for doing works that don't leave the building in a state that can be insured, then I think it would have difficulty continuing to collect the excess insurance premium because it would have caused an increase in insurance by not doing the remedial works properly. So it probably wouldn't be able to pass on those costs through the service charge. And under the developer pledge, developers are signing a contract that says they will do all life safety critical works in a proportionate way by reference to PAS 9980. What that means in practice, I cannot tell you. It will depend entirely on what the contract says, and we just have to hope it will match what the Building Safety Act says. But that will be a product of negotiation between the developers and the government. But the developer pledge should definitely cover all buildings built in the last 30 years, so at least back to June 1992, if not before. Hopefully, and the noises coming from the government is even if you're not an eligible leaseholder under the waterfall, for example, because you have 5 buy-to-let properties, if the developer's fixing the building, that shouldn't matter. Whether it will matter in practice, time will tell. But the pledge seems to be that you fix the entire building, regardless of the makeup of the people who have the flats in that building. The downside to the developer pledge is if the developers don't do their job under the agreements, it's up to the government to enforce the pledge against them. Leaseholders won't be party to the contract, so they will have to get the government to take action against the developers. So again, which landlords have to pay up under the waterfall? So we've covered the ones who are connected to the original developer. Landlords with net assets of 2 million, that figure can be changed by secondary legislation, but 2 million per qualifying building, so one taller than 11 meters or with at least 5 stories. They have to pay for works if they meet that test. And then we've already talked about the rest of the information on that slide. So another common question, can a landlord be forced to do works? There are powers that are coming in to go off and seek a remediation order or a remediation contribution order. They're also coming in, those powers are coming in on the 27th of June, but we're missing some of the important details to make those provisions work in practice, in particular because there's no form to fill in to get the first tier tribunal to do it. So I very much doubt the first tier tribunal is set up and ready and waiting for these applications to come in. We've covered the changes to the Defective Premises Act, but what the Act also does is allow the High Court to make something called a building liability order against associates of the developer, but that won't be enforced until some point in the future to be chosen against the government. The potential claims against cladding and construction product manufacturers who either breach regulations or are convicted of an offence in relation to regulations, they also come into force. Those powers come into force on the 27th of June. But how good those claims are, considering they involve quite technical regulations, is anybody's guess. But they're supposedly there from the 27th of June as well. And that is far longer than I intended to speak, and I feel quite hoarse. But if there are any other questions, I'm happy to take them. And as I say, the recording of this evening and the slides themselves will be going up on the EOCS website.
Yeah, thanks, Liam. I think everyone will probably agree that it's extremely complicated. Really,
I have a headache myself.
Yeah, I mean, I don't know how you do it, honestly. There's so much detail. I'll just have two questions for you. There's loads and loads of questions that have come through, so we'll kind of note all of those down, and potentially some of them will go into the Q&A after. There's also the leaseholder protection fact sheet that the government released, which has a lot of information that would be covered in the questions that everyone's been asking. So I'd advise people to go and have a look at that as well. Two questions, I suppose, that have come up quite a lot in the chat. The first one is there anything that can be done other than what's written in your lease to stop service charge demands coming until the 7th of June? Is there anything, for example, if you're getting bills through now, that you can do to kind of delay that to ensure that you're covered?
Well, so the government has made a request that landlords shouldn't be sending Section 20 notices and getting the ball rolling on issuing service charge demands until after the protections kick in. But that's just a moral obligation. It isn't a legal obligation. Ultimately, there's not a lot you can do to if you have an unscrupulous landlord who gets in and sends a demand, you're unfortunately probably stuffed. That's just the way it works.
Great. Not the answer we probably hoped for, but the truth. And secondly, is there anything you think that can be done to sort of change the bill now, or change any of these things in regards to RMC and all of the under 11 metre caps or anything, to try and influence the government to make changes to the bill or in secondary legislation? Or is this the final deal from the government?
I think as far as the government's concerned, it's pretty much the final deal, but they are looking to do something for enfranchised blocks, RMC blocks and RTM blocks. And they've also said if you live in a building that's under 11 metres tall, you shouldn't be getting a bill. And if you do, you should be contacting the government so they can look into it. But that's potentially a double-edged sword, because if the government gets involved, it's possible that where things have been missed, for example, because the fire brigade hasn't been out to look at it, they could then go out and look at it and say, oh, no, this is much worse than everyone first believed. So it's up to you whether you choose to involve the government in an under 11 metre building, but certainly send details to UCAG and EOCS if you're under 11 metres and you want someone to have a look at it, and I wouldn't say give you advice on whether you should report it to the government, but someone to have a look at it and give you a fresh pair of eyes on the situation.
Yeah, there are a few people asking where they can get advice, and I think that is kind of actually raising your case directly to the government, your local MP, obviously reading as much as you can through the fact sheets and calls like this. But to repeat the disclaimer, I guess, that we had at the start of this call, that the advice that Liam gives and the advice that we've kind of tried to give in the Q&A is really just opinions, and very knowledgeable opinions, I guess, in Liam's case. But definitely it's worth getting your own legal advice and legal opinion, because there are so many different situations and different cases, and everyone's case is slightly different, so it's always worth getting your own advice. I will just quickly pass over then to Giles, who's also on the call from End Our Cladding Scandal. I think it's probably worth noting that there may be things coming up that will be led by EOCS and UCAG and the other regional groups as well. And one thing from me before I pass over to Giles is that obviously there's over 300 people on this call. Everyone seems to be impacted and have loads of questions and have lots of concerns about how this might impact you. And I'd just strongly recommend that you do get involved in any initiatives that are coming up led by EOX and UCAG, because the more people that are shouting about this, the more people who come to the rallies and bring their family and friends, it really does have an impact. So a slight plug from me there for just staying involved and doing as much as you can. And Giles.
You've done my bit now.
Sorry, I just stole the words from your mouth.
No, you're all right, no, just mainly say thank you to Liam for his insight and kind of explaining this horror show for the bill. I can say shit show, can't I? Because it still is. I mean, if you think about where we were a year ago, we're further along, but I think the simple point is that we've still got campaigning to do. It's still not a comprehensive solution, so we're going to carry on campaigning. So thank you also to Sophie, of course, for hosting the Q&A, and we did try to keep up with the chat and the Q&As, but we will take those away, and as Liam said, there'll kind of be an FAQs produced. We'll keep updating the UPS website. Some people have asked where that website link is. You should all know it off by heart now, really, to be honest. So, basically, apart from the secondary legislation areas, which Liam's touched upon, we know there's still gaps, whether it's the developers signing up to the pledges. I think it's now something like 39 out of 53. They've talked about the small and medium-sized enterprises. They'll pick up in the next phase. Obviously, what we need is that phase to happen as soon as possible. So there's still a lot of questions that are being asked, a lot of questions that we've asked government ourselves, and we keep being told we'll get answers back as well. And so as soon as we get that information, we'll share it as much as we can, as widely as we can. As Sophie said, there is still media interest in there with all that's going on in the world. So the focus right now, we're hopeful for a piece this week on ITV, although always subject to confirmation of the breaking news. They're obviously looking at the gaps in terms of if you've got a developer that hasn't signed up, if they're a member of the HBF or a small and medium-sized developer, they're looking at those areas. Under 11-metre buildings as well, people are still in those buildings that are being forced to remediate. So we're trying to push the government on that. We have shared some cases. So if you are in that situation, please do email us and let us know. One thing we're looking at is potentially drawing up kind of a template to kind of respond to Section 20s before the end of June. As kind of Liam's gone through and is quite clear, it's kind of so complex, all the different scenarios. It's not that easy to do, but we'll see what we can do in terms of providing, if not, a full-on template, then at least questions that you can ask based upon the buildings you're in. One thing I did want to mention, the final point, we are looking at a potential judicial review. Thank you to all those who've contributed to the fundraising for that initial piece of work. The slight difficulty is, as Liam said, that we need the act to actually be published. So we've got the final version so we can actually look at the issues and then have a list of the main issues based upon kind of public law, human rights law as well. So as soon as that act's available, the initial work on that will start. And again, we'll keep people updated. So yeah, we're still, things are better, but we're still somewhere off, but we're all going to keep carrying on. So thank you, Liam, Sophie. Thank you guys who rock on up at the rallies and keep tweeting away. So yeah, that's all I got. Thank you.
Perfect, thanks. I think we'll end it there. So thanks everyone, and see you all soon.
Bye. Bye, everybody.